we have a fascinating panel before us. In this panel, we will continue our inquiry towards existing means for prosecuting Russian crimes in Ukraine. This will be second part of this topic. We have the privilege to meet four distinguished academics, scholars, and lawyers. On the screen appears the face of Dr. Patryk Labuda, who will start this panel with his paper. Patryk Labuda is a Swiss National Science Foundation Fellow at the University of Zurich. He is both lawyer and historian. The second contributor of this panel is Professor Dan Plesch, a lawyer, professor of diplomacy and strategy at the University of London. Then we have the presentation delivered by Professor Karolina Wierczynska, Polish lawyer, professor of public and international law at the Institute of Law Studies in the Polish Academy of Science. And last but not least, we have the presentation of Professor Nadia Boyadijeva, also lawyer, who is currently a long-term visiting professor at the Davis Center for Russian and Eurasian Studies at Harvard University. So I would like to ask Dr. Patryk Labuda for taking the floor with his speech, which is entitled "Countering Imperialism in International Law: Examining the Special Tribunal on Aggression from Post-Colonial Eastern European Perspective." Please, Patryk Labuda, this is your time.
Okay, thank you so much to the organizers. Maybe I should just check, do you hear me?
Yes, everything is perfect.
Okay, great. I think you cannot see me, but okay, as long as you hear me, that's all that matters. So yes, thank you again to the organizers for the invitation. I regret not being there with you in person. Sadly, I had a scheduling misunderstanding that prevented me from traveling. So you have the title of the talk on the screen. I want to make just three disclaimers before I get started. So first of all, it's a work in progress. I'm still thinking through some issues. So I welcome comments, critical comments. That's absolutely fine. These are not sort of fully developed thoughts. The second disclaimer I want to make is that I'm not lobbying for a special tribunal. I'm not lobbying for a specific form of tribunal. I'm sort of on the fence about this, but I'm hoping that the thoughts that I will share with you today will maybe enrich the discussion around the tribunal. And the last thing I will say by way of introduction is that I'm thinking about this from a comparative perspective. So I'm thinking about different tribunals, primarily on the African continent, and how they might relate to the special tribunal for aggression against Ukraine. So you see the title, it's really about the special tribunal, but from a sort of post-colonial Eastern European perspective. And so I think before I say anything else, let me just try and define those terms. The first comment to make about Eastern Europe, the way I understand the term, at least for the purpose of this talk, is that it is the post-Soviet space. So I include in that term things like, or countries like Poland, the Czech Republic, not necessarily sort of borderline cases like Finland. The second, but I don't think that this is the most important issue. It's just a sort of a definition. I need a working definition. The more important term, I think, is post-colonial, which is, again, a sort of a contested term, which defies sort of a simple definition. But again, for the purpose of this paper, I understand post-coloniality as a critical approach to the study of post-imperial relationships rooted in unequal hierarchies of inclusion and exclusion, and a status quo that is defined by sort of discriminatory relationships inherited from the past. And, you know, this is, I think, familiar ground for many international lawyers, especially international lawyers who are familiar with third world approaches to international law. So sort of the TWAIL movement, the insight that international law is co-constitutive of these unequal relationships, I think, is by now more or less common sense. Now, my remarks build on TWAIL scholarship, but what I do, I guess, is a little novel in that I apply the post-colonial term to Eastern Europe, whereas usually when people think about post-colonialism, it's about the Europe and the non-European world, so the third world, or, you know, the West and the non-Western world. But especially now in the wake of the war in Ukraine, there is a tendency to try and analyze Eastern Europe as also sort of a post-colonial space. And so that's something that I want to try and do in this presentation, and see where that leads us with respect to the issue of aggression, and specifically the Special Tribunal for Aggression. So yeah, I'm hoping essentially that this presentation will just provide some additional insights and help us to think in a more nuanced manner about the issue of aggression and the Special Tribunal. So with those preliminary remarks out of the way, let me switch to the next slide. So here's this is an outline of my presentation. Many of you will know that the debate around the Special Tribunal has been pretty heated. You know, the idea surfaced in late February 2022, so just a few days after the full-scale invasion of Ukraine. And I think most of you are aware of the facts, so I'm not going to spend too much time on that. In sort of to summarize this in 30 seconds, a Western academic published an article in a newspaper. That idea was then picked up by other academics and think tanks. And then the all-important development was that that idea was endorsed by Ukraine itself. The Ukrainian government decided that it made sense to move forward with a special tribunal for aggression. And since March, Ukraine has been coordinating with other states to find a viable path that might make the special tribunal a reality. And I think it's really worth emphasizing that the states that have been pushing for this primarily are Eastern European states, which is a point that I will come back to later. So there are a few contested issues, a few things that are generating controversy when it comes to this tribunal, and that are making negotiations on the tribunal complex. And I want to focus on the three that you see on the screen. So the legal basis of a potential tribunal, the issue of immunities under international law, and then the perceived legitimacy of the tribunal. And I think all three are intertwined. I do want to emphasize that. But I guess what I'm really doing with this presentation is I'm suggesting that a post-colonial lens can illuminate this debate, enrich the debate around those three issues. So let me start with the first issue. I'll talk about this briefly. Immunities, I will talk about very little. I'm happy to come back to that in the Q&A, but then I'll focus especially on the issue of legitimacy and how that relates to post-colonialism. So when it comes to the legal basis of the tribunal, essentially the controversy here seems to be that we need to decide, we, meaning the international community led by Ukraine, whether it should be an international tribunal or a hybrid tribunal. Should it be 100% international, or should it be grounded on Ukraine's domestic criminal law? And I don't think it's an exaggeration to say that this is a controversy, because those of you following this will know that just 10 days ago, the German foreign minister gave a speech in The Hague where she endorsed the idea of a tribunal, but she made it pretty clear that she wanted it to be a hybrid tribunal. And then just a few days later, Eastern European states and a few other countries came back with a non-paper endorsing the international route. So it seems that this is not just sort of an academic debate. It's certainly more than that. Governments are also divided on this issue. Plenty of scholars have also weighed in. I'll come back to that because I do think it's also shaping the debate. So in this presentation, I can't do a deep dive on what those terms mean. What is a hybrid tribunal? What is an international tribunal? What is an internationalized tribunal? But for the sake of clarity, I do want to just briefly mention what the options are. So the international route is that it would be an international tribunal. It would be an international agreement, sort of like a treaty that is signed between Ukraine on the one hand, and then the United Nations, either the UN General Assembly or the UN Secretary General on the other. And so it's really an agreement between an international organization and Ukraine. The hybrid route is that it's essentially a domestic court grounded, as I mentioned, on domestic criminal law with international elements, international judges, prosecutors, potentially other international elements. There's also a sort of a third option, which is a regional court, that this would somehow be a court that is endorsed by either the European Union or the Council of Europe. But I don't need to get into that for the purpose of this presentation. In general, I would say that I do think that this is a bit of a false binary, this debate. It's a heated debate, again, not just among academics, but as I mentioned, among governments. But the binary itself is, from a purely legal perspective, misleading, because the tribunal would either way be based on Ukrainian criminal law. That much is clear, even if there's an agreement between the UN Secretary General and Ukraine, the jurisdiction of the court would come from Ukrainian criminal law. So there will definitely not be a purely international tribunal. An international tribunal set up by the international community, like in Rwanda, the former Yugoslavia, where under Chapter 7, the Security Council really crafted a tribunal sort of out of thin air. That is not going to happen because Russia has the veto power, of course. So at most, it's going to be an international agreement. But again, the jurisdiction will still come from domestic Ukrainian criminal law. Now, so in a way, the question is sort of how international will it be, as opposed to whether it really is international, and how domestic will it be, as opposed to whether it will be domestic. So why is there really controversy? I mean, this is the first point that I want to raise, and I think that post-colonialism does, I think, give us some tools with which to think about these issues. For me, this really isn't a legal debate so much as it's about how international criminal lawyers think about these issues. There is now a mantra among international criminal lawyers that the future of international criminal law is domestic. you know, it's sort of a dogmatic statement that you will hear repeated time and again, especially, you know, the link is made to complementarity, the Rome Statute, supposedly domestic prosecutions are better than international prosecutions, supposedly domestic courts are more effective than international courts, et cetera, et cetera. And, you know, I think the debate around the special tribunal and whether it should be international or hybrid ties in a little bit with this, but I don't think that the arguments that are put forward are particularly compelling for a hybrid court, because, you know, the main argument for hybrid courts when it comes to atrocity crimes, for example, in Africa, so genocide, crimes against humanity, and war crimes, the reason we have hybrid courts bringing it closer to the domestic level is because you are building capacity for the future. That's already happening in Ukraine. It's not clear to me that we need a hybrid tribunal for aggression to build capacity for future aggression prosecutions. I don't really see the logic there. And so this sort of idea that it has to be hybrid is inherited from international criminal law more generally, but it doesn't seem to be particularly compelling for the specific case of aggression prosecutions. But it does matter, again, this issue of international versus domestic, and I'll come back to this later, for sort of the legitimacy of the tribunal, if it's international, that means there's buy-in from the international community, whereas, you know, if it's a hybrid court, it's more local, it's more domestic, that means it has less buy-in from the international community. And so that really does matter, and we'll come back to that in a moment. You know, the post-colonial issue that I would mention here is that it seems that Ukraine has pushed for the international route, as far as we can tell from public statements, not just Ukraine, Eastern European states, but this is often ignored in the debate around the special tribunal. But I think we can come back to this maybe later. Why would it be useful? Why would Ukraine and Eastern European countries think that it makes sense to prosecute aggression through an international as opposed to a hybrid tribunal? And to be fair, I don't think Ukraine has really articulated a compelling rationale that has been sold to the international community. So let me move to immunities. I just want to ask one quick question, because I hear a bit of an echo. Are you also getting an echo?
No, the quality of sound is perfect. And by the way, you have 3 minutes more.
Oh, okay. Well, I wasn't aware of any time limits, so that complicates matters a little bit. Okay, so thanks. So I'll just skip the immunities part because yeah, I don't think maybe that's the most important issue. I'll just go straight to the legitimacy issue, and I'm happy to take questions about immunities later, but let me just talk a little bit about the legitimacy issue, because I think this is the most sort of complicated issue here. So you know, the question is, in a way, I want to ask a counterfactual, which is, why would we not prosecute aggression? This question, why would we not set up a special tribunal? And this question is oftentimes not framed in those terms, but I think it's helpful to actually try and reverse the question. Very few people outside of Russia disagree that aggression has been committed. The crime of aggression is on the books. It can be prosecuted. And so the question is, why not set up a special tribunal? And here I think analogies are useful to think about. You know, there's a special tribunal that has been proposed for South Sudan, a hybrid court. There's been no massive discussion around why we should have a specialist tribunal for South Sudan when the ICC could intervene. You know, there could be a referral from the Security Council. There's no big discussion. The reason is because South Sudan has stated very clearly that they want it to be a domestic hybrid court. And end of discussion, nobody really questions that. So why is it that when Ukraine says very clearly it wants a special tribunal for aggression, there's this big debate about whether we should have a tribunal at all. And I think, again, here, the post-colonial perspective can be illuminating. I mean, there are legal answers that you're going to hear. Supposedly ad hoc courts are bad. We should not have more ad hoc courts. Special courts are denounced as sort of symbolizing victor's justice. And then, we have the key argument, which is that the Rome Statute has been ratified. There is an international criminal court, and so that is the way forward. That's the universal solution that we should now prioritize. Now, I mean, in reality, the reason we're having this big debate, and I think this is really where post-colonial perspective sheds light on this issue. There are two reasons, right? There's the double standards critique, the selectivity critique. The idea is that we shouldn't be prosecuting here because other cases of aggression have not been prosecuted, right? And Iraq is sort of the core argument that gets trotted out repeatedly. I've provided the other examples on the screen. And then the other issue is that Ukraine and Eastern Europe are repeatedly conflated with the West. And so, sort of this liminal status of Eastern Europe, Ukraine at the borders of Europe is ignored in this debate. And I think it really frames their narratives around this tribunal. And so in the 1 minute that I now have to try and just briefly say a few words about those narratives, I do think that, the narrative has been shaped to a large extent by this conflation of Eastern Europe with the West, right? That Eastern Europe is just an emanation of the West. And you see this a lot in narratives that are pushed by academics. Just a few days, I think yesterday, Luis Moreno Ocampo, so the first prosecutor of the ICC, also published a blog post on just security where, he's making exactly this kind of argument, arguing that it's the West that is pushing for the tribunal, just completely ignoring sort of the Ukrainian role in pushing for this tribunal. And I think, this is really where it's interesting to think about how these narratives work, right? Because a lot of the commentary that you will read frames this as a Western proposal, right? A Western proposal. Philip Sands, Gordon Brown, they're the ones who are really pushing for this tribunal, the hypocritical West, the UK, France. And, we really enter into the realm of what's been called West-plaining here, because, if people really paid attention to the facts, they would realize that it's actually those Western countries that are opposed to the special tribunal, or they have been until very recently. They have actually done everything in their power to potentially block the tribunal from being established, right? And so, that is one way in which I think reframing the issue sheds new light on the negotiations around the tribunal. I think another thing that it deserves at least mention is really the Ukrainian agency. Again, why is Ukraine pushing for a special tribunal? Why is it pushing for an international tribunal as opposed to a hybrid court? That's something I'd be happy to talk about. I mean, I have a few hypotheses. I can't really get into that now because I'm out of time, but I would mention here sort of the legacy of Nuremberg. Katerina Busel has written an interesting piece on this where she explains how a tribunal, an international tribunal, could undo the legacy of Nuremberg. And the last thing I'll just say about sort of, the post-colonial perspective and how it can really reframe our understanding of the special tribunal is that, in reality, Eastern Europe, when it comes to resisting wars of imperial aggression, has a lot more in common with global South countries than it does with Western countries. And I do think that Eastern European scholars and diplomats really need to take a more proactive role and sort of emphasize that angle to make sure that sort of, the special tribunal isn't it doesn't sort of it's not established for the wrong reasons, because people have sort of a wrong understanding of who it is who's pushing for this tribunal. So yeah, I'm really rushing here because I'm mindful of the time. I mean, I do have a conclusion, but I think I got my main points across. Yeah, I think I'll just stop there. I mean, this is a summary of the argument, and if there are any questions, I'm happy to expand on that and you know, explain in the Q&A. Thank you.
Thank you very much, Patryk, for your very inspiring talk. I would like to remind a very little known fact that the term Eastern Europe was invented and constructed by Russian diplomacy in 18th century in order to legitimize partition of Poland. So this is additional context to your inspiring talk. And now I would like to invite to the stage Professor Dan Plesch, who will present a talk which has titled Precedents and Practice for Ukraine, UNWCC in the Indictments of Adolf Hitler, Myths of Head of State Immunity, Domestic and International Indictments after Second World War. The floor is yours.
Hello, Berlin. Is anybody still awake? It's bad to fall asleep in somebody else's lecture. It's even worse to fall asleep when you're giving it. I shall try and be awake. So, who needs their dinner? Okay, there's a couple of us standing between you and your dinners. I'll try and entertain on this gruesome topic. So, if you have a device, you'll see I'm speaking to the website, unwcc.org. All of the screens I'll show you are on the website, one way or the other, and you might find it useful going forward. So the indictment of Vladimir Putin for crimes committed on his orders in Ukraine is obviously a key issue of this conference and for the world as a whole. The brutal attempted murder of the Ukrainian nation and the likely resulting suicide of the Russian Federation stains the history of the first part of this century indelibly. But I do want to thank the Institute for this cracking conference. I have learnt so much. Many of the presentations, I'm sure I'm not the only one, reduced me to tears, and as they should, with their power. And it's been an absolute treat. I want to thank my colleagues working on the UN War Crimes Commission project, particularly Dominika, Natasha and Jacob, for help in developing this presentation, and I take full responsibility for it, just in case they don't like anything I have to say. I wouldn't want anyone to get fired. So I was going to say a word about Iraq. That finally has been said, thank goodness. I want to talk about head of state immunity, personal and functional immunity of senior leaders particularly, and point more widely at the use and practice of states through the United Nations War Crimes Commission. So, just to say a word about this slide. It's what I call a traffic ticket for war crimes. You may not have seen it before. It is all in the Pilecki archive. Most of it is on my website, and more is coming. But if you look at this document, well, point one, Adolf Hitler, we'll come to that. We know heads of state can't be indicted by other states, but who's indicting them? The Czechoslovak government. Well, more of that in a moment. But if you see here, this is a form, a registration number for the crime in the top left-hand corner. This is the high analog age. Not in the digital world. That did exist, younger people. We did have an analog world, and the whole world was in black and white. It's amazing. It's from December 1944. For those of you who watched the movies, this is like a week before the Battle of the Bulge kicked off. and it's a form to fill out who's charging who, what's the serial number, who's the name of the accused, and if you look through these files, you will see it has other categories. What is the crime in international law? What is the crime in domestic law? What is the likely defense is part of this formula. And by 1948, they had processed 8,000 dossiers against 36,000 individuals, mostly in Europe, but also in the Far East. A huge level of internationally organized prosecution. This commission was a formally constituted legal, diplomatic, multilateral body. It wasn't any kind of ad hoc organization with 16 member states sitting in London, a subcommission in the Far East, which we won't go into. It was founded by well-known figures, René Cassin, Trygve Lie, future Secretary General of the United Nations, and others, and many senior legal figures from Central and Eastern Europe were part of it. Which is just by way of background. The accepted view on the issue of immunity essentially is that this didn't exist, or if it did exist, it didn't matter. And this is what I want to discuss, because in an entirely non-academic, non-legal way, I have to say that 60 or 70 years of legal scholars and judges have not done their homework. And if you look at some of the other work that I've been involved in, this has been shown to be the case in general about the Allied response to Nazi atrocities, fairly conclusively, but not specifically on the issue of immunity, which I want to go into. So, yes, we have the ICJ opinion or decision, but we also have other conflicting precedents, the Pinochet case, which you'll be familiar with. The fact the United States and Canada have legislated against the sitting Venezuelan president, Maduro, and other cases and laws being established largely around the realm of corruption or sanctions, targeting high officials, taking a rather different approach than that of the ICJ. The International Law Commission as well has had exhaustive but rather inconclusive discussions about various aspects of immunity. Strangely, they do not, however, take note of a book published by the British government in 1948, which was a history of this commission, published by the then leader of the commission, a very senior British law lord, Lord Wright, and it covers a lot of interesting topics you might want to look into at various points. And in chapter 10, they discuss the question of individual responsibility of heads of state. Now, when I first attempted to write on this topic about 12 years ago, the infamous Reviewer 2 said my article for a history journal should be rejected because this history was in all good libraries and no one could argue it had been ignored. Well, it has been ignored because in this chapter they say explicitly that Adolf Hitler was charged by the Czechs and that the Commission endorsed and supported this indictment so that he was listed by them as an international war criminal subject to arrest by the member states. He was put onto a list of people subject to arrest, along with most of his government. Now, this doesn't quite compute with the official view. When I say rudely that the ICJ hasn't done his homework, the reason I'm particularly specific about that is that who made these decisions? I mentioned Cassin, Trygve Lie, even Lord Wright, a Master of the Rolls, a very senior judge. But the first chair of the commission was the British knight Sir Cecil Hurst. And who was he? Well, at the time he made these decisions, supporting, signing the minutes and supporting the decisions of his member states, he was still a sitting member of the ICJ itself, and he had been president of the ICJ from 1934 to 1936. So this decision is presided over by a sitting member of the ICJ and a former president. So how the ICJ can say that there is custom and practice that no individual state can prosecute another defeats me. The polite, I say, version is that they haven't done their homework. Now, it wasn't just the Czechs, and the Czechs brought together, it is worth saying, and the Pilecki-Institut has the records, the Czechs brought together a dossier of charges, 2 different sets, and each of them runs into hundreds of pages. The first set is very legally specific and crafted and deals with the issue of what was argued to be illegal courts and legal processes established by the Reich in Czechoslovakia. And then they go to liturgy and other issues. Not long after, the Polish government in London brings in a set of charges involving Jews specifically, other categories. The Czech charges refer to the Versailles list of some 30, which we'll hear more of shortly, the Versailles list of war crimes which was used extensively by member states, and the Hague Conventions, and also national legislation of Czechoslovakia, Poland, and later Belgium as well joined the effort. Each of these countries had, in their London exile, created war crimes legislation so that they had a domestic basis to pursue international crime, to pursue war crimes, as well as the Hague Conventions and the Versailles list. And in bringing charges before the Commission, the states had to specify these. Now, it is an interesting state, am I right? There's an interesting state practice here in that the Commission, which existed in huge political pressure from the Anglo-Americans not to do anything, for pragmatic reasons, to be polite, about Nazi crimes, and the exiled governments in London, with some help from within the British and American governments. There's a whole mini-series there about that, to pursue Hitler on the basis of, and the other Nazis. They couldn't get an international court. They drafted a process for international criminal court, and that was rejected in Washington. Other crimes they sought to develop, I won't go into now. But what they did do was not having the opportunity to develop hybrid courts, and this goes back to the St. James's Declaration. They said, we need international legitimacy and support for our national actions. And so this is what the Commission did. They performed the role of a examining magistrate or a grand jury of considering whether there was in the Anglo-Saxon tradition a prima facie case. And if there was, then the state was able to use that to legitimate their domestic concerns, but also the accused was then put on a wider list, subject to arrest by any of the countries where they happen to crop up. And that, I think, is an important practice that might be appealing to Ukraine. Now, as I say, I think there's an issue for the International Law Commission and for the ICJ in not picking up these issues, because it hasn't been a secret for these 5 years. In 2017, the Associated Press ran a fairly major story that Adolf Hitler had been an indicted war criminal at his death. And there have been other things since, which haven't produced any curiosity, really, from The Hague. And I think they should do. and we should bring it to their attention. I think it is worth saying for the record which states were in this commission and how forthright they were, so that when Sir Cecil came to sign the minutes, he was doing so because the United States endorsed the indictment of Hitler, because the United Kingdom endorsed the indictment of Hitler, because France endorsed the indictment, because India and China, sitting on the commission in London, through their embassies, endorsed the indictment of head of state and senior officials of the government, and other countries of Western Europe, Netherlands, Norway, Luxembourg, Greece, Yugoslavia, and of course the prosecuting countries. And last out I should mention is Belgium, which brought charges very shortly after the revelations from Auschwitz, specific to that. So you have 3 states, all of whom are now members of the European Union, who seek to indict Hitler and his henchmen for domestic and international crimes on a bilateral basis. And each of those 3 states, members of the European Union, have their indictments supported by 14 or so other countries. Now that seems to me to fundamentally change the paradigm with which we consider head of state and functional immunity. Now you can say, oh, well, that was all very interesting to hear from Plesch, and we'll go on and go back to normal. Well, that's up to you. But to my mind, this provides an opportunity for Ukraine, in particular, to pick up these indictments, to use them to pursue a bilateral prosecution, and frankly to ask state by state, here we have the dossier, you supported indicting Hitler, will you now support us on the basis of your 1940s practice to indict Putin and his generals and his staff, or not? Oh, I'm sorry it's all been lost for 60 or 70 years, but maybe that's because you had all the files locked up because you wanted to protect the Nazis. That's another story. That's a whole other story. But that, to my mind, is a huge opportunity for Ukraine. Now, I may be wrong, and it's not for me to tell Ukraine what to do. Similarly, when it comes to prosecution of perpetrators from high to low rank, the trial reports of leading states, and there are some 500 full transcript trial reports of American military tribunals from this period, and many from the United Kingdom, where you see the prosecutions in many cases for crimes against POWs, which I think may be interesting, but the type of charges, the type of personnel who are charged, the types of laws that are used, cultural crimes, for example, are prosecuted, environmental crimes are prosecuted by Poland. The types of these precedents are generally unknown, and they shouldn't be. So I would hope, thank you, I would hope that this material, which the Pilecki-Institut has available, and which we're also happy to assist with, can be of use to you. I will close, if I might, with a word about the crime of aggression. And if you read the Commission's book and the minutes of its committees, which are in the footnotes of the history, and you can, the minutes are on the website. I'll just to go back to trial reports for a second. On the website, you will see there are huge PDF documents, I'm afraid, but you'll see available to you, are the trial reports of member states, which have theoretically been available for many years. The Commission has extensive debates about aggression, which are very pertinent today. And I particularly want to perhaps leave you with the thought of those members of the Commission who argued that the Kellogg-Briand Treaty on Aggression of 1927 provided sufficient evidence to pursue a crime of aggression. The French argument was it didn't have an enforcement provision and therefore wasn't valid, which I think is a little cheeky given everything else that gets used. It doesn't have an enforcement provision. But that's what the French were reduced to in committee on that point. Now, again, those countries who, for understandable reasons of their own state behavior, aren't so keen on the crime of aggression, don't rush to use the Kellogg Pact. But I would suggest that countries who have been aggressed might find it quite useful as a basis in international criminal law. So as an old friend used to say, if you have been, thanks for listening.
Professor Plesch, thank you very much for your excellent lecture, which convinces me surprisingly that this old Latin proverb that historia magistra vitae est is not outdated. You can take some practical knowledge from the past, and I would love to hear from our Ukrainian colleagues what they would think about this proposal. And now I would like to invite to the stage Professor Karolina Wierczynska, who will present a lecture, Prosecuting Heads of States from the Treaty of Versailles and its Travaux Préparatoires to Current Problems of International Law. The stage is yours.
I would like to know how it works. Okay. Okay. Thank you. Thank you very much. As Patryk Labuda was arguing about establishment of the special court currently, and Professor Dan Plesch took us to the considerations during the Second World War. I will take you to the events just finishing the First World War. I mean, I will talk about some events that happened a year ago, 100 years ago, with some few years more. So I will dive a little bit deeper than Professor Plesch. I hope not to drown, of course. I will speak about prosecuting heads of states, how it was proposed by the Commission on the Responsibility of the Authors of the War and on enforcement of penalties. I will try to prove that prosecuting heads of states is a necessary element in the development of international criminal law, and without that, our discipline will not develop, and also this model of supremacy of great powers will be maintained in international community. I will start with this Commission on the Responsibility of the Authors of the War and the Enforcement of Penalties. I will speak about this as a commission. So after the First World War, the preliminary peace conference decided to establish this commission, and it consisted of 15 members, as you can see, and great powers. Every great power had 2 members in that commission, and the states of interest had one person in the commission. So that is how we had 15 of them, and this. This commission, it was supposed to discuss the responsibility of the authors of the war, and also the degree of responsibility, and also the breaches, the responsibility for the breaches of laws and customs of war. And also it was supposed to discuss whether it was possible at the time to establish the special tribunal. So they were to inquire the constitution and the procedure of such an international court. And this report was presented in March 1919. And I will not refer to all those bullet points you can see here, because I want to focus especially on the individual responsibility. So I will not refer to the responsibility of states. So I will skip, for example, the responsibility of the authors of the war, which referred to states which were guilty of this crimes, and the crime of aggression, of course. So main findings of this report what I'm going to talk about refer to this responsibility, personal responsibility. And what I want to say is, for example, about this commission discussed, for example, the rank of the person, and they found that this rank is not protecting this person from the responsibility before the properly constituted tribunals. And this, in the opinion of the Commission, included also heads of states. So we had this principle widely known at the moment. It is called the irrelevance of official capacity or irrelevance of official position. And the provision on this irrelevance were put into many international instruments. Also, the discussion was on the immunity of heads of states. And some states found that this privilege is not the absolute privilege, and it shouldn't be treated as fundamental privilege. And they found that it is rather recognized before domestic courts. It's very interesting, because now we mostly use immunity and apply immunity in international law, and then they thought it is some kind of a tool used before domestic courts. And they thought that the individual could be prosecuted by the national court, and it might be some problem with prosecuting, if there was a problem with prosecuting a person before domestic court, they thought that character of international court is a little bit different. They did not develop this issue, but there was such a statement that the character of this international court is quite different. Also, states proposed to create a high tribunal. Interestingly, they did not use at the moment the notion of international tribunal, but they used the notion of a high court. An international tribunal as a notion appears only in the conclusions. So states discussed the possibility of the prosecution of former head of state, but they also discussed the question of the consent. Some states thought that it should be necessary that the state withdraws, that the state gives a consent to prosecute a person. So basically, it is something like a withdrawal of immunity of this head of state. But at the same time, they underlined that it should not be like that the person will not be prosecuted, that, for example, head of state will not be prosecuted for grave crimes, because such a solution would actually shock the conscience of civilized mankind. So they really thought it should be necessary to prosecute heads of state. And also they were talking about responsibility of subordinates, not only the superiors. There remained, however, some special, I'm still talking about the report of the Commission. So they were thinking about how to settle special court, and they thought that there should be special charges to be recognized before this court. So among these charges, you could see, for example, charges against persons who committed massive crimes, or when the orders were executed in the battlefields of several nations. So the crimes were could be characterized as really international crimes. And at the conclusion, those features, it might be also interesting for you, those features of this special court, which could recognize only special charges, was that it was supposed to be composed of people from many countries, from people representing great powers, but also states of interest, and also Portugal and Czechoslovakia. And what were the conclusions of the report? Mostly, states thought that it should be possible to prosecute any crimes and violations of laws and customs of wars. And for the first time in this report, we could see that there appears a notion of amnesty. And states thought that we should not claim the amnesty. The person should be surrendered to the court to be tried. Also, that those conclusions of the report, they broadly referred to the cooperation of state to that this enemy government should deliver any evidence, any persons, any names, instructions, copies of orders, etc. And the report was not accepted anonymously, but there were some objections which were raised by Japan and United Nations. For example, United Nations, United States. What I said, United Nations. I'm sorry. It's because I'm tired already, and a little bit unconscious, maybe a little bit. So United States, they did not want to deny the responsibility of heads of state, but at the same time, for them, it was more moral or political than a real criminal responsibility. They also did not want to support any establishment of international criminal tribunal. They thought, for example, that there is no standard and fixed notion of the humanity. Also, that they did not want to include into material jurisdiction of this court the notion of laws of humanity. This discussion was repeated on the crimes against humanity after the Second World War finished. And Japan also thought that they had this idea of responsibility of the head of state, which was more traditional. They thought that we could actually apply responsibility towards heads of states, but only in the situation when a head of state actually knew what was going on, and this head of state had any competence to intervene and, for example, to prevent the crime. And this report actually brought a mechanism or a scheme of the future prosecutions of heads of state, and it was later partly included into the Treaty of Versailles. You can see here Article 227, which actually was referring to the prosecution of former German emperor, I mean ex-Kaiser, Wilhelm Hohenzollern II. And states were planning to prosecute him for the offense against international morality and the sanctity of treaties. So it was not this discussed law of war and custom of war, or it was not even the law of humanity, which was discussed by the Commission, but some invented charges which were not known to any country in the world at the moment. So we now, of course, know that he wasn't prosecuted, that it was ineffective, but it gives us some idea about how it was supposed to look like. So they were planning to establish a special tribunal, which was supposed to be international tribunal, and also they proposed to prosecute also the criminals of the lower ranks, and they were supposed to be prosecuted either before military tribunals of one concrete country, either before military tribunals composed of members of the military tribunals of the powers concerned. So as you can see, we have a scheme for international tribunal, but at the same time, the competence were given to military courts of concrete countries and military international courts composed of members of military tribunals, of domestic military tribunals. So actually, we had this first scheme of the international prosecution of atrocities committed during First World War. And what were the principles established by the Commission? I will repeat here that it was this irrelevance of official capacity. So it was repeated then in the Nuremberg Charter and also in Nuremberg Principles, in the Convention on Genocide, also in the statutes of ad hoc tribunals, and now permanent criminal tribunal. Again, there was a principle included that immunity is not an absolute privilege, and it could be mirrored in this Article 227, which actually wanted to prosecute German emperor. Now we have article in the International Criminal Court Statute saying that immunities do not bar the court from the jurisdiction. And I will not discuss the issue of international tribunal. It was discussed and developed by Patryk Labuda, but report, as you can see, was building a certain scheme, was formulating a special idea of how this first international prosecution should look like. And at the same time, it was breaking this paradigm that the state is exclusive forum to prosecute its own citizens. And also this was breaking this paradigm, referring to the responsibility of heads of state and also responsibility of subordinates and superiors. Thank you very much.
Thank you very much for this insightful and very competent lecture. And now I would like to invite to the stage Professor Nadia Boyadjieva with the lecture with the title, The International Criminal Tribunal for the Former Yugoslavia, a Precedent or a Warning?
Thank you very much for giving me the floor, and thank you very much to the organizers for inviting me to this prestigious conference in Berlin. I have a task to keep you to keep you awake, and at the same time to present my presentation. So what I'm going to do, I cut it substantially, but I think that during the conversation, the discussion afterwards, if you have any questions, so I will be glad to respond, or afterwards during the dinner and tomorrow. And I also have a task to deal with this. My topic is the International Criminal Tribunal for the Former Yugoslavia, Precedent or a Warning. So we are coming closer to the current situation as we started during our panel from 1944, 1941, 1944. Then we went back to 1919, and now I would like you to come back to the current situation and with a little bit history about the International Criminal Tribunal for the former Yugoslavia and its achievements. So this doesn't work. Or maybe I cannot work with you. Oh, okay. Okay, so, and I made a PowerPoint presentation. I'm not a native speaker, it's obvious, so I would like to make sure that you actually understand what I'm saying. So what if we are going to determine whether Russian war crimes and crimes against humanity in Ukraine can be punished, we need to look at other recent instances in which criminal tribunals have been set up. The Nuremberg trials in the late 1940s provide one such instance, but there are more recent situations that we can look to. And I'll bring to your attention the International Tribunal for the former Yugoslavia, ISTY, the International Criminal Tribunal for Genocide in Rwanda, and also I'll mention the extraordinary chambers in the court of Cambodia. This is a hybrid court with some international judges and some Cambodian, something that was offered already yesterday and today in a few presentations by our colleagues, type of hybrid court. Also with, yes, and for atrocities perpetrated by the Khmer Rouge. So my task here is, as a professor in international law and international relations, to give an overview of the International Criminal Tribunal for Yugoslavia and to suggest its relevance or lack of to Russia's war in Ukraine. So the International Criminal Tribunal for Yugoslavia was established by the United Nations Security Council resolution on the 25th of May, 1993. It operated until the end of 2017, when it was disbanded. And during the nearly quarter century of its existence, a total of 161 people were indicted, of whom 90 were convicted and sentenced to prison terms. The tribunal had a responsibility for investigating and prosecuting 4 clusters of crimes that we have discussed, especially yesterday, perpetrated on the territory of former Yugoslavia in the 1990s. First, grave breaches of the Geneva Conventions. Second, violations of the laws or customs of war. Third, genocide and crime against humanity. So here I would like just to mention that the war of aggression was not included. And it has been mentioned several times, the term aggression, what does it mean? But it wasn't included in the work of the tribunal. So what are some of the positive results? The positive results are primarily that the major war criminals, such as Slobodan Milosevic and Ratko Mladic, were held to account, even though Milosevic died before he could be convicted. For this, the Serbian government's cooperation was crucial. Numerous lesser war criminals were also convicted, and the tribunal was able to function despite persistent differences among the permanent members of the United Nations Security Council. And the situation now is absolutely different because Russia is a permanent member of the United Nations Security Council. What are some of the drawbacks and shortcomings of the tribunal? Relatively few of the perpetrators of war crimes and atrocities were ever indicted, and too often governments refused to cooperate. The collection of evidence that would hold up in court was extremely difficult. That was a topic of our afternoon discussion, especially part 1. Differences among the permanent members of the United Nations Security Council had detrimental effects on the functioning of the tribunal. Of course, there are much more achievements and obstacles in front of the tribunal work, but I just wanted to mention the most important ones. So the tribunal's jurists had only ambiguous leeway to prosecute the launching of a war of aggression, because we know from the Nuremberg Tribunal that this crime was fundamental to all others. The tribunal's practical inability to pursue it was a serious obstacle to prosecuting those responsible for the war. And let me point a few lessons and implications for dealing with Russia's war in Ukraine. The gathering of key evidence must proceed throughout the war, and the evidence must be securely held by impartial observers. Ukrainian laws requiring all evidence for court proceedings to be gathered by Ukrainian investigators could pose obstacles for any tribunal. Today I learned a lot about Ukrainian courts and obstacles in front of them to collect evidence, also about German, and I'm very grateful to our colleagues. Also, the other obstacle should be, it's kind of obstacle, but it's also prerequisite to collect evidence. NATO governments must be willing to share sensitive communications, intelligence that will help establish the guilt of high-level officials in Russia. The prosecution of the highest level officials will be crucial to prevent an accountability gap. Also, a tribunal must have clear leeway to prosecute the launching of a war of aggression. To the extent that existing international tribunals can be used, this will circumvent obstacles that might arise within the United Nations Security Council. Indictments and arrests will require also backing of NATO forces, and because no one should be under any illusions that Russian war criminals will voluntarily turn in themselves. And so success will be formidably difficult. It was difficult in the cases of Yugoslavia, in the case of Rwanda and Cambodia, and it will be more difficult in the case of Russia war in Ukraine. I would like to make a few, do I have 3 minutes?
Yeah, sure.
3 minutes of conclusion. Oh, thank you. So the involvement of international criminal court in this, the current conflict is already a major step for the prosecution in international crimes. As the situation being monitored by the many international organizations, International Criminal Court and the International Court of Justice, there still may be possibilities for criminal prosecution for the crimes committed during the war in Ukraine, but we all agree that this is highly unlikely in the near future. And also, as it was said yesterday, it must be noted that the time frame of international criminal law is usually long. As the conflict is ongoing, it's reasonable to expect individuals, of course, to be tried in front of International Criminal Court before the conflict ends. And despite that, the involvement of the International Criminal Court, also the public condemnation of violations of international law, and the possible resolution of the issue with the jurisdiction that will be tasked with the crimes committed during the conflict can positively affect the situation. Considering the establishment of the International Criminal Court as well as any of the international criminal tribunals aims at the preventions of the international crimes, equally with the successful prosecution and bringing to justice of the perpetrators there. And this is a benefit of the ongoing discourse in relation to the punishment of the violations of international law during the conflict in Ukraine. Despite the uncertainty, there seems to be an impetus on, this is the positive and more optimistic view, impetus on the international scene driving forward with unprecedented political backing. The issue with the bringing to justice of the perpetrators of international crimes in this particular case, a lot of options have been mentioned here. The question is if any of them will work, especially those ad hoc tribunals. But an internationally binding solution in regards to the international crimes committed during the war in Ukraine, this is my pessimistic view, will be inevitable, albeit in the near future. Thank you.
Please, all participants of our panel are invited to the places. I would like to encourage our public to posing some questions. We have a few minutes for a little discussion. I think all lectures are very, very inspiring. Sorry, I don't understand. Is it okay? Okay, because Patryk is looking at us. Probably this is the reason. So please raise your hands if you have any questions. I will provide you a microphone. Yeah, Professor.
Thank you very much. I must be brief and, well, I would be biased. Well, when looking into the beginnings of the whole realm and analyzing the works of the War Crimes Commission, then, well, at least the Polish sources, well, mention Tadeusz Cyprian as the person who formally brought it to the attention of the War Commission. I'm not saying about, well, formulating the formal motion yet. Well, during the discussions, well, it was Professor Cyprian, Tadeusz Cyprian, who, well, at least according to our writings, is, well, the author of it. Could you please comment on it? Thank you.
I'll take your word for it.
Please take the mic.
I'll take your word for it. I have no particular knowledge of his work on that issue, but forgive me, it isn't quite the point. The point is that several states indicted Hitler and senior officials, and that half the European Union, the United Kingdom, United States, formally supported them, and that they were endorsed in doing that by a serving member of the International Court. But plaudits to Mr. Cyprian.
Any other questions? Yeah, Professor Kramer.
My question's for Nadia Boyadjieva. You mentioned that for the International Criminal Tribunal for former Yugoslavia, there had been only 161 indictments, and I'm wondering, given the scale of the atrocities, especially in Bosnia and Herzegovina, that doesn't seem like that many. So I'm wondering, what was what was the major obstacle? You mentioned some of them, but especially the gathering of evidence that would hold up in Kuwait. So I'm wondering what other obstacles were there?
You have the mic here. Yeah, it's working.
Well, as we have discussed yesterday, there were many obstacles in front of International Criminal Court in Yugoslavia, and besides the achievements, some of them I have mentioned already, and we all appreciate the work of the International Criminal Court. It acts pretty slow, and it's very not only time-consuming, but also it is very expensive. Its work takes the budget for the court is huge and also I would here we speaking about the issue of International Criminal Court. It's not that the International Criminal Court is not functioning well. Simply the structure of the court is such it takes very slow, and also a lot of time is needed to collect for all evidence, for the sufficient evidence to be collected. And also we should maybe mention another problem that is connected with the political will of the international community, or maybe certain countries that are not willing to contribute or not interested that much of contributing to the work of the International Criminal so you mentioned, yes, of the International Criminal Court. And also bear in mind that many important countries are not, they didn't sign the Rome Statute, as for example Russia didn't, United States, and this and other powerful countries. So for such organization to work better and properly, and to have the support of from the international community, I think that main international actors on the political scene of the world political scene should be involved in the work of this court as well. Of course, many other problems coming from the structure of the court and everything else, but these are details. So I'm combining legal and political sides also as obstacles.
Thank you. I see another hand.
I have a follow-up question, because not so long ago I listened to a report, and you said there were only 161, and in the report they said it is a real success story, because 161 people were accused, and all of them ended up in front of the whatever. They got a trial. Yeah, exactly. And so I wanted to ask you, is it a success story or is it a failure? What would you say?
Can I join with the answer? It's a great success. And I wouldn't say so 10 years ago. But then I could observe the works of ICC, International Criminal Court. And I have to say that after 20 years of ICC prosecuting of war criminals, we have actually 5 people prosecuted. And in context of International Criminal Court for former Yugoslavia, we had much more of them after 20 years. So we could compare exactly 2 international institutions, 2 international courts, and say that the ICC is not effective, while in comparison with this court, the International Criminal Court for former Yugoslavia was very effective. But I wouldn't say so 10 years ago.
Please allow me pose a question myself. I have a question to Professor Nadia Boyadjieva. You mentioned already that there is a big difference between Serbian war criminals and Russian ones. Serbian war criminals like Milosevic or Mladic lived in Serbia, who was conquered by NATO armies. Serbia ruled by this criminal regime which attacked Bosnia, had to step out. And Russian war criminals live in Russia, and they will never leave Russia. So how would you translate this experience, this juridical experience from one reality to another?
Well, I would say that there are a lot of differences between the two conflicts, and it is a completely different topic. So we cannot compare conflicts now. We can, and also we cannot compare I think the work of the two tribunals, because International Criminal Court is a permanent body. Those
nobody will hear you.
Sorry.
No. Please, close.
Okay, so I'm
sorry, but that's technical.
It's a directional microphone. You have to put it up
exactly.
So I have to speak up.
No,
even.
Speak into it like that.
Okay, like that. Yeah. Okay.
Like a singer.
Okay. So what I meant to say, so you combined you raised not one question, but you raised for me several questions. So here you have two completely different conflicts. First of all, one conflict is very complex, ethnic, ethnic, religious, etc., conflict in former Yugoslavia. You cannot compare with the war. I would say war or military conflict, this conflict, that they're completely different. And also, so you're talking about the fact that for high-ranking politicians will not be prosecuted. Yes, that's correct. Who is going to leave Russia from high-ranking politicians? In order to...
You can try them in absentia, for example.
No, you cannot, because International Criminal Court doesn't do that. So you cannot do that.
So maybe this way is
no,
closed.
It's just closed, so there is no other way. So in other words, that's why my pessimistic voice, my final sentence was so pessimistic that I don't see in the near future any opportunity to put high-level politicians and from military in Russia in front of international court. Also, we have this completely different. Okay, so also we have another obstacle, if we speak about obstacles, that Russia is a permanent member of the Security Council of the United Nations. So how you're going to abolish its veto of Russia? No resolution can pass, if Russia doesn't vote for it. So it's absolutely so. The hands of the Security Council, it cannot act properly according to the Charter of the United Nations.
So the conclusion of your statement is that we have to invent another way. In my question, there was implicit said that we cannot use the example of this tribunal for Serbian war criminals. We cannot, because the circumstances were completely different. So I thought maybe you will defend this case. Okay.
Personally,
no, it's working.
Personally, I think that if I was Ukraine person, I would not want to go anywhere near the international criminal system, which is a deeply corrupt bank for lawyers and judges who make huge amounts of money out of it. I think Ukraine pursuing charges themselves, with the international support of the international community, but not interfering with Ukrainian processes, is a far cleaner and simpler, a more rapid process. One may also look at other processes. For example, in Africa, the UN has supported mobile courts around in the Congo and elsewhere, which have been pretty just and effective and speedy in bringing justice. And I think one could look at other models than these Baroque constructions, the most egregious of which is the Lebanon Tribunal. That is how I would look at it if I was Ukrainian, and that I think is how one could get some justice. As to whether there's any point, well, 3 years from now there may not be a Russian Federation. You bring charges against people, well, maybe, if nothing else, it limits their holiday destinations to northern Cyprus because of where they can't travel. Those who started this process in World War II, when the Nazis were winning the war, didn't think, oh, well, we shouldn't try it because it'll be difficult to get the Nazis at the end. Of course, it was for other reasons. But at the time, 42, the Nazis were winning, and they still thought it was a good idea. So I wouldn't want to say, don't do it because you never get the Russians. You don't know.
Thank you very much for this explanation. Dominika, the last question.
Thank you very much. I would like to refer to these remarks about effectiveness of international justice that is raised since yesterday practically on every panel, and this gap between law and practice, or even questions about failure or lacking effectiveness of these tools that are existing, including these very pessimistic conclusions presented just a few minutes ago, and refer also to Patryk Labuda's talk and this analysis using this post-colonial methodology, this context of geopolitical circumstances influencing the decision-making process, but also understanding of different institutions and needs. Like you said, this experience of resisting imperial violence and aggression is typical or much more common for particular region, and in Europe it will be Southern Eastern Europe. Dan Plesch also pointed out that during the Second World War there was some kind of resistance, or at least passive attitude towards the idea of defining the legal basis for pursuing war criminals. Patryk, do you think it's the moment right now, these discussions we are having, like to maybe fulfill this gap or make the sources of this problem, the understanding of this gap between law and practice, between the demand for justice and bringing criminals or alleged criminals to justice, if this methodology you are proposing, if it's the right moment to understand this problem using these questions?
Thanks so much for the question. I want to be brief also because it's almost 6:30 and I don't want to open a can of worms. But I do want to say that in general, I find the pessimism, from my perspective, it's a personal observation. I find the pessimism short-sighted, if I may say so. When the ICTY was established in 1993, if you go back to the records and read what people were saying, everybody thought this would be a complete waste of time, a failure. Nobody would get arrested. Nobody would be prosecuted. A paper tiger. We hear the exact same arguments today, that this is a waste of time. Let's not waste our time on the special tribunal. And I think this is just a lack of imagination. I think the way we can influence the situation potentially, despite all the flaws of international criminal law, its lack of effectiveness. The only way you can potentially influence the leadership in Russia is by setting up a tribunal, an international tribunal, not domestic courts. Domestic courts are never going to have the reach of an international body, but an international tribunal that has buy-in from many states, and that is the challenge. That is the challenge that we need to talk about, but that has buy-in not just from a handful of Eastern European countries, but also Western European countries, but also then the emerging powers, the middle powers, India, Turkey, Saudi Arabia, Indonesia. We need to be talking about those countries also and why they should care about this. And that's how you get to the leadership of the Russian Federation, by setting up an international tribunal that can potentially influence the politics in Russia down the line. And I mean, I understand that this is controversial. There are a ton of objections to what I just said. And, you know, if I were there with you, I would go to dinner and we would have a nice conversation about this. But unfortunately, I'm going to stop there. Maybe this is controversial, but that is how I see it. And I think we need to be thinking about this in more global terms and not necessarily be too pessimistic about international criminal law, despite all its well-known flaws.
Thank you, Patryk, for this manifesto of power of imagination. Let this be our last word. Thank you very much, all participants, for a marvelous contribution, and thank you all for attending to this very last meeting.